Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your basically undead host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. How's it going? How is it going? I feel just great. And by great, I mean like I'm dying constantly. Woo. Damn it. I just took some cough medicine, so hopefully that should kick in just a minute. Yes, I have la COVID. I'm on day 8. Day 8 of COVID. It's fucking annoying, man. It is not fun. It is not a good thing. It's not like dire, right? Like I'm not going to die tomorrow or anything like that. But shit. I'm just exhausted. Constantly exhausted. And I have no appetite. Which makes things worse, because, like, I'm exhausted. I also basically haven't eaten in 4 days. So, yeah. Yeah, have fun. A whole bunch of people asked me if I regret not getting the shot or something. No. I don't know why I would suddenly regret something. That's not how I tend to operate. But, and a lot of people I know who got the shot also got COVID at the same time I did. So it is what it is, man. You get sick from time to time. And this one, it just sucks. And the brain fog is, I don't know what the brain fog is. I mean, I guess I have a little bit of it, but I think it's mostly just because I'm so fucking tired. Yeah. Zombie Logic. Let me tell you about that. It says, get the monoclonal antibody shots. It helps a lot. Oh, does it? That would be nice. That would be cool. Let me tell you about monoclonal antibodies. Okay? Let me tell you about how they work in my town. So I've been trying to get the fucking doctor to give me any kind of treatment at all. Any of them. I'm like, hey, I heard Regeneron, that's the antibody treatment. I heard the Regeneron's good. Maybe ivermectin, maybe like a steroid. You got anything for me? Can I have something? And this is days and days ago. And they're like, oh yeah, the antibody treatment is the first line of defense. I'm like, okay, well, how do I get that? And they're like, oh, they'll call you. Since you have a positive test, they'll call you. Okay. So I wait, no calls, right? So I'm messaging with the nurse like every day. I'm like, I still haven't gotten a call yet. And I've called the clinic and the hospital, and I'm calling everybody, trying to get through to the fucking antibody nurse. And finally today, I sit on hold for 35 minutes and then get a message that they'll call me back. And so then they finally do, like, another 30 minutes later. I'm just laying on the couch like a useless lump. And they say, okay, I'm going to send a message to the antibody nurse. Thanks. That's what I've been asking for like 6 days. So they finally do. The nurse calls up Lady Rackets, because she's got it too. And for Lady Rackets, she's on day like 13 of this thing. And they're like, yeah, we only do the antibodies within the first 10 days. So you can't get it to her. And then they said, and I'm like sitting there listening. I'm like, tell him I'm on day 8. And so they said, yeah, he's not over 65 and he doesn't have a BMI over 25 and he doesn't have diabetes. So I'm literally not old enough and not fucking fat enough to get treated for this goddamn disease. The hell is that? They're like, is he a smoker? No. If I was a smoker, apparently I could get the antibodies. I'm so pissed. It's so stupid. I hate everything. I hate everything about it. I just wanted him to pump some of them sweet, sweet antibodies into my veins so I can maybe knock this out a little bit quicker. Oh, and then, so I've been talking to a nurse for days. My doctor finally pops in the message thread. It's like, oh yeah, by the way, you should schedule some appointments, for your other symptoms. Because here's the deal. Like the COVID is a cough and fatigue and all that stuff. But I've got a nasty sore throat and a lump in my lung, which is probably some brand of pneumonia, right? And so I'm like, hey, maybe like some antibiotics for that because I'm probably got a bacterial infection. Maybe I could do some other stuff. And the doctor's like, oh, yeah, you should set up an appointment. Of course, I had already just set up appointments. I had set up appointments for me and Lady Rackets. She's like, oh, cool. So then I get a phone call 45 minutes after setting up the appointments. We canceled your appointments. Yeah, since you didn't get the vaccine, we're going to cancel your appointments at the clinic. Just go to the ER. And I'm like, but I don't need to go to the fucking ER. I'm not dying. I'm just uncomfortable. So they're telling me to go waste, like a whole day at the in the ER in an ER bed. Just take up, well, two ER beds, one for me, one for Lady Rackets. Because that sounds like a good plan. Just stupid. It's just stupid. So anyway, what a waste. What a waste. So, you bet your ass I'm not going to the ER today or tomorrow. Speaking of which, tomorrow, while I should be at the ER, I will have Sargon of Akkad, Carl Benjamin, on the show. I believe 3 p.m. Watch for the announcement. We'll have Sargon on tomorrow during the daytime. And so that'll be fun. I'm not entirely sure what we'll be talking about, but last time went fine. And I think we'll find good things to chat about this time as well. You can find him at the podcast of the Lotus Eaters. That is his very cool political podcast that he has right now. And yeah. So that being said, what we're going to do today, I'm going to be done bitching about COVID in a little bit. I just wanted to give everybody an update on my situation. But I don't know if we're going to do the whole thing because it's like 3 solid hours. And I don't know how long I'm actually going to be able to go tonight. Because I'm telling you, like, Last night I slept 15 hours, something like that, 9 p.m. to 1 p.m. It is just exhausting. But we're going to see how far we get. But we've got the Kyle Rittenhouse hearing today. Yeah, urgent care would just send me straight to the ER. But yeah, so I don't know if we'll finish the Kyle Rittenhouse hearing today. I'll preview with I'm pissed off about some of the stuff from it. I haven't watched it yet. I just know some of the results, not all of them. So we'll see how that goes. The reason there's no announcement on Twitter is because I have been banned from Twitter for 12 hours, starting just after noon. I think 12:45 is when I get my account back. So to all the people who messaged me on Twitter, Twitter said that I would have access to my DMs. I'll show you. Actually, I'll show you because this is such bullshit. Look at this. Is it? Okay, you see this? All right. The fuck did my screen go? Here we go. Okay, so you guys can read. We have determined that you have violated the Twitter rules. So I told a congressman to find bleach and drink it. I didn't think that was that bad. Like, how is that? First, he has to find the bleach, and then he has to drink it. So there's like a multi-step process there. You know what? This is what gets me. Somehow, that is promoting self-harm. But if I said, find shit and eat it, that wouldn't be promoting self-harm. Which seems weird to me. Right? That doesn't seem fair. All right, here we go. So I want to show you what happens, though. So yeah, but you're limited to only sending direct messages to your followers. No tweets, retweets, fleets, follows, or likes. Your account will be restored to full functionality in 1 hour and 26 minutes. Watch this. Oh, look at that. See how I get to go straight into Twitter? Oh, nope. Back here. So I literally can't do what they said I'm supposed to be able to do. Fleets are on the way out. I see a bunch of people who are saying, what's a fleet? A fleet is like an Instagram story. It's you know how everybody adopted TikTok's thing, right? Like little short videos. Twitter had it too. Or sort of. They weren't just videos, though. It was like you could post a tweet that would disappear after 24 hours. Like an Instagram story. More than a TikTok, I guess. And no one used it. No one used it, so they're getting rid of it, but they still have it for now. Do you not have a sneak account? No? No, I don't. I don't have a sneak account. Oh my gosh. This Dr. Pepper cream soda is delicious. Feels better on my throat than just about any of the medicine I've been taking. Okay. So that's why I didn't post on Twitter, and that's why I haven't responded to anybody on Twitter. I'm supposed to be able to, but I can't. So fuck Twitter. I hope Twitter drinks bleach. There. You know, I told Lady Rackets I would stop telling people to kill themselves, and I just can't. I'm trying. I'm trying, girl. Whoops. Okay, I'm getting the super chats pulled up. Why am I even on Twitter? Believe it or not, tweeting about the show brings in more people. My Twitter account's been growing lately. It was flat for a very, very long time, but it started growing again. I'm very, very proud. I'm like 5,000 people away from where my original account got banned. Don't forget to wash your mic in warm soapy water. Yeah, I soak it after every show. I just dip it down in some nice soapy water. So it's safe to say Ty was the one who gave you the COOF, right? Yes. Actually, I think it was one of my kids. Gab is way better. I don't grow on Gab at all. God damn it. Okay. Let's read some of these chats. Yosh Ken says, hey, Nick, talk about the ninja versus special ops in California. I don't know what the hell that is. What is that? Cinema Queen, I don't think I got it at the art show. I think we actually, we got it before the art show. We probably spread it to people at the art show, actually. A ninja attacked a base? Wait, what? Ninja versus Spec Ops? A ninja with a sword assailed a U.S. Army Spec Ops unit in California? What? What the hell? Here we go. A man wearing full ninja garb attacked members of a U.S. Army Spec Ops unit in the middle of the night in the California desert, setting off a scramble for safety, resulting in at least 2 injuries, according to police and other records. The incident occurred a little after 1 a.m. on September 18th when authorities in Ridgecrest, California got word of a sword-wielding man dressed as a ninja on the loose. Kern County Sheriff deputies found the suspect had assaulted a victim at the scene with a sword and thrown a rock through a hangar window, hitting an additional victim in the head. He's going like full-on ninja. Like he's using projectiles, attacking from cover. Surprised he wasn't throwing like those little darts. Like, holy shit. The victims are members of the 160th Spec Ops Aviation Regiment. Soar! According to the Stars and Stripes newspaper, which states that the military personnel were at the airport as part of training exercises. Describes how a staff sergeant was smoking a late-night cigarette near an airport hangar when an unknown person wearing full ninja garb approached him with a question. You know who I am? The man... You know who I am? The man asked. The sergeant said he did not. Do you know where my family is? The man asked. When the sergeant said he did not know, the person in ninja garb began to slash at him with a katana sword. I mean, if you're gonna do it, I mean, if you're going to attack a special operations team, you better know the way of the blade. Your Nippon Steel better be ready to meet all challenges. Why? The report states, adding that the sergeant's leg and phone were struck. The sergeant ran, jumped a fence, and reached a building where he joined others from his company. As he and a captain locked the doors and called 911. This is a Spec Ops military team. They're calling the cops? The assailant kicked and punched doors and windows, according to the report, which has redacted the service members' names. Like, You'd think they'd just draw a gun and shoot him. I mean, I know he's a ninja. He'd probably dodge the bullets. Can you imagine? You get attacked by a ninja with a sword. You're just out trying to smoke a cigarette like a normal human. You're just out. Oh, this cigarette's kind of nice. Do you know who I am? Do you know where my family is? You have brought the dishonor to your countrymen. Like, oh shit. Report came in at 1:19 a.m. of a suspect in a ninja outfit complete with a sword. Report cited at least one victim. Oh my God. More than 20 minutes after the initial contact, the blotter says a 911 call came in from someone at the airport saying 26 Spec Op military members were hunkered down in a hangar wondering where help is. 26 of them! There are 26 special operations military being held down by one based Bushido blade. Like, come on. The ninja did not obey deputy's orders. Ninjas don't obey orders. Of course not. What do you think they are? Samurai? They owe fealty to no lord. Police officers located the ninja suspect on a nearby road, but the man refused to follow commands and brandished a sword at the deputies. Sheriff's official said projectile rounds were used but were ineffective, it added. Instead, the man ran. When deputies used a taser on him, he dropped the sword and deputies were able to take him into custody. He was identified as Gino Rivera, 35. Rivera was arrested for attempted homicide, assault with a deadly weapon, brandishing a weapon with intent to resist or prevent an arrest, along with vandalism and obstructing or delaying a peace officer in the performance of their duties. They should hire him. They should, you know what? As punishment to the 26 Special Forces guys, they should have to get trained by this guy. They should have to get trained by Gino Rivera. Both the sergeant and the captain required stitches for their wounds, but were cleared to return to duty. The 160th SOAR's missions include using helicopters to insert Navy SEAL teams and other special operators. Trains for night missions, and not very well, apparently, as some of its operations take place under cover of darkness or in the very early morning. The soldiers in Inyokern were attached to the regiment's 2nd Battalion, which uses Chinook and Black Hawk assault helicopters as well as Gray Eagle drones. The battalion is based at Fort Campbell, Kentucky. Well, now we know the weakness. All you have to do is just have ninjas. If you just have ninjas, you can stop all the special forces that you need. That's amazing. That is amazing. Oh my gosh. Okay, well, thank you, Yashken, for that story. I had no idea that happened, but it makes me really, really happy. Wolfgang Deo says, this crap is getting ridiculous. They even harassed my damn senator at ASU on the plane and at the airport. When does Lascivious Bellum start? Please. No, thank you. ISJ322 says, Ralph, we see what you're doing. You're not as smart as you think you are. Receipt, the king yesterday at 10:22 p.m. Let's see how good he is at BitChute, lol. I don't know what that means. Interview the ninja when? I guess when he gets out of prison in forever. Mario Carter 13 says Nick's opinion on video game storytelling is bullshit. Refuses to elaborate further. Walks away in silence, blasting Linkin Park through earbuds. Oh. Okay. Joshua Sanabria says, Nick, this happened because you went to the fancy party with the lizard people and they infected you with the COOF spores. Again, I'm pretty sure we brought them the COOF, although we didn't know it was the COOF at the time. Craig Litton says, let's go, Brandon. Okay, somebody fill me in on the let's go, Brandon thing. So I know that I'm seeing a lot of fuck you, Biden, right? Lots of it. Like whole stadiums are screaming, fuck you, Biden. Is the media reporting it as let's go, Brandon? Is that what's going on? Or fuck Joe Biden? Yeah. Are they reporting it as let's go, Brandon? Does it like occur to them that doesn't make any sense at all? Like who's Brandon? Brandon is suddenly the most cheered for man on the planet. Let's go, Brandon! Yeah! Oh boy. NASCAR was saying fuck Joe and reporter tried to play cover. Okay, perfect. Good. God, what a disaster the media is. What a disaster. Like, just accept that a bunch of people don't like Joe Biden. You know, only half the country doesn't like him. Like, at least it's not like anybody was surprised that half the country didn't like Trump either. We're just a massively evenly partisan divide on presidents right now. There's no shock to any of this stuff. Like, you're going to have a huge amount of people who don't like whoever's in charge. Even if it was like 25% who didn't like him, you'd still have incidents like this. To be fair to the reporter, it was a live broadcast. Okay. Wow. That's fantastic. Marty Lund says, Flutang clan represent. Do side effects of this cut-rate Chinese bioweapon include being perpetually tardy? Yes. Yes, I was laying in my bed, staring at the ceiling, going, I got to get up and go downstairs so I can do the show. Whew. Oh, by the way, I got to give a couple shout-outs real quick. Shout out to my bros, Good Logic and Attorney Tom, who both sent very nice messages today, encouraging me to get better. To Good Logic, who had scheduled me without my consent on his show tonight. I'm sorry, buddy. I only had the energy for one show. Eldon Bainling says, you've lost weight. You look thin. I haven't eaten in 4 days, man. I'm probably down about 8 pounds at this point. But yeah, I think tomorrow I'll be eating a little bit more. But yeah, so Joe is very gracious. I'd love to do his show. I just couldn't do it today. But he was checking in on me. And Attorney Tom, he even offered to run the stream and full on grift and do nothing but grift for hours. It was super nice of him. But yeah, so nice of them to reach out like that. Very bro-like. Scott McKnight says, Christ, Nick, you are later than Kentaro Miura with the next Berserk chapter. Ooh, I don't want to be later than Kentaro Miura. That would mean the COVID wins. Nikuyasha says, that's how it was for me. Super tired and lost my sense of taste, so I didn't want to eat since I didn't enjoy it. Just slept the whole damn thing off. Yeah. My sense of smell and taste are still here. So that's a good thing for me. Sika Lother says, it isn't the CN virus you have. It is the Delta India virus. The virus came from India. When are you going to hold India accountable for creating this mutant strain? Long live the great motherland. Hashtag Pajit problems. It can't be. India's not real. So that can't happen. Or that can't be true. But I'll blame it anyway. Thanks, Bainling. No, I probably do have, from what I've been reading, I probably do have the Delta variant. Because I've got probably a sinus infection as well. But Frederick Little says, hey, Nick, I'm 29 years old today. Can I get in a Mitch McConnell voice birthday shout out? I'll try. Also, I hope you feel better soon. I just want to come to the table and offer a happy birthday to Frederick Little. Very important that his birthday is recognized by the chamber, and as a former leader of the Senate, I think it's my duty to do so. So happy birthday, Frederick Little. There you go, buddy. Matt Maka says, Nick, if it makes you feel better, you are a useless bum. And also, you look older than 65, so that's your silver lining. I blame the haircut and the gay cruising, by the way. If you die, can I get the painting set? Sure, because you made me laugh and also cough. Lost Bullet says, Nick, you look like Death and Ruth Bader Ginsburg's baby they named Hillary Clinton did a face swap with Queen Elizabeth. Jesus. Ouch. Shinobu Tezuka says, Nick, this ninja was watching 13 Assassins with you and was inspired by your movie of heroism, Sour Ops, BTFO. Guys, if you missed 13 Assassins watch party with us, that's a sad thing for you to do. Go out and watch it immediately. It's probably Takashi Miike's best movie. And I say that without having watched many others other than Ichi the Killer, which I love. But 13 Assassins is one of the best action movies ever made. Ever made. In any country, in any timeline, it is so fucking good. You need to watch it. It's not a Korean movie, it's a Japanese movie. I don't know how to describe it any better than that. You will. It is really difficult to find a more action-packed thrill ride than 13 Assassins. Bad Vibes says, if I need permission from the government to be with my family and friends, work, and survive, then fascist Fauci is going to get an ouchie. He'll die eventually. He's old. Renee Villarreal says, if you ran/biked more, you'd be a bit better. Most likely. Yeah. Get well soon so you can eat. Lost 10 pounds the week I had the virus. Yeah. Yeah. If I would have kept up with running this year, I probably would have been in better shape. But I didn't. Because I loved you. I loved you all too much. And therefore I wasn't running. See how I did that? I blamed you for me being lazy. And fat. Wick Dipper. Oh, this is good. I'm going to read this one. Looking good, Nick. Keep up the good work. Maybe don't eat for another week or two. Thank you. Aw. Now I understand anorexia. See? I got one compliment and now I don't want to eat ever again. Oh, man. It is so... Jesus, hold on. I wore this long sleeve shirt because I've had a tendency to have chills lately, but, yeah, it is not, I am not having chills right now. I am melting. Okay. Let's start this Kyle Rittenhouse thing. Huh? Or wait. No. Let's do this other thing first because it's really not that long of it's just a short little bit. As you guys know, I occasionally see comments, right? And I occasionally see comments, and I've noticed something. There's been a couple Melinda Scott simps. One of them, I'm pretty sure, is definitely Melinda. And the other one might also be Melinda. Where is it? Where did they go? Was it here? Okay, let's see if I can find it real quick. Here's the first one. So, wait, why can I not pull up the whole? Okay, here we go. Look at this. Look at this simp. Brian Conrad. What the fuck? That was not what I wanted. There we go. Brian Conrad. So here we go. Can you imagine simping for Melinda Scott? Here we go. I'm trying to decide if you're actually this bad of a lawyer or just a bad person. I'm a bad person. Obviously, the thing for her to do is hire a real lawyer and go through due process because, again, obviously, there's a case, as it's reasonably foreseeable, given Kiwi Farms' reputation, that publishing someone's personal information there would lead to harassment, defamation, and emotional distress. And in fact, that is the primary motivation for doing so. It's weird that you'd spend nearly an hour covering this and I don't know why it cuts off his comment there. And yeah, this is really fucking weird. Cause it says he ends up saying, because I respond to it, but he ends up saying, I hope you don't have you don't get a Kiwi Farms thread. And I'm like, bro, I have one. Refresh the page. Let me pin it. I'm going to give him the pin of shame. There we go. There we go. There we go. You'd spend nearly an hour covering this and not even mention that. In fact, just minimizing the harm done and deflecting the blame from the party responsible. Sure hope you don't end up with a Kiwi Farms post someday, my guy. And so I respond, I have a Kiwi Farms post, my guy. They say terrible things about me. It doesn't matter. If she hired a lawyer, she'd still lose because her target, Josh Moon and Kiwi Farms as a website, are not the right targets. Section 230 covers the service. I'm curious if you're a lawyer. If you are, you don't seem to understand very basic elements of free speech. And he says, Did you read Section 230? It's really short. So this is how you know this guy has no fucking clue about 230, right? Like you can tell this guy knows nothing about how 230 works. It actually just protects service providers from civil liability and taking action to restrict access or availability of material that is harassing. It doesn't give them a blank check to host that material. It does, though. It absolutely does. It gives them blanket liability immunity for hosting that material. So they're wrong. You know, when I read that Kiwi Farms thread you mentioned, it seems like they have an overall positive opinion of you. Okay, now go read the Dick Masterson thread, the PPP thread, and the Ralph thread. I think I'm beginning to understand the one-sidedness of this video. I'd want to stay out of their bad side too, because as we both seem to know, they have a reputation for harassing, defaming, and emotionally distressing the people they target. One might say it's reasonably foreseeable that they would do so. It doesn't matter, by the way. This doesn't change anything. The reasonable foreseeability that someone on an internet message board will make fun of you isn't grounds for a lawsuit. Now, I do think an honest person would mention that a real lawyer could help Miss Scott select the appropriate targets for lawsuits in which they might reasonably have civil liability, and of course could aid her in correctly following the legal process in that effort. But again, I totally understand why you wouldn't. She's not my client. That's the first thing. Second thing is, I don't care. There are 10 billion people I would help before Melinda Scott, and I'm not helping any of them either. I guess it's better to pander to Kiwi Farms than to stir that hornet's nest. I don't think you need to lie to me, yourself, or anyone else about your motivations here, though. What motivation? Like, why? Like, does he think that, like, if I suck up to Kiwi Farms, that that's going to ingratiate me to the monolith that is Kiwi Farms? Again, these people don't understand anything. You clearly don't understand the court's broad interpretation of 230. Literally is a blank check to host the content because the decision to not remove content is the same as the decision to remove content. I noticed you dodged the other question. It's okay. It shows. Yes, they're not a lawyer, obviously. But I wanted to show you this other one real quick because that's... Hold on. Filter. Response status. I responded. Apply. Here it is. Wait, where'd it go? God damn it. Okay, and then we'll do the Kyle thing. Look at this. This is Yahuwah Reigns, which I guarantee you is Melinda Scott. Right? He keeps calling Melinda dump, but so far she outmaneuvered Joshua's lawyer. I mean, I guess if losing your case entirely is outmaneuvering, she's playing some real 8D chess. You're also forgetting the fact that all those orders from the district court are void because they're in appeals. Nope. What proof do you have that her lawsuits are frivolous? You have no facts or laws. This is guaranteed Melinda. Yahuwah Reigns. There's 107 videos? Wait, this is a real person? Is this her husband? Or boyfriend? Or your 27th husband? Oh, there's no audio for you yet.
You know, to further prove
Spit
that
it out!
The United States is Babylon. You know, Babylon, Mystery Babylon from Revelations 18. That's what I'm referring to. It's a prophetic nation that is prophesied to be destroyed. Same with the daughter of Babylon that was prophesied from Jeremiah. Anyways,
What are you talking about?
You know, I can't even say the name of the legal system. You know, people ask for JUSTICE, but they don't understand what they're asking for.
Oh my
You know,
God. Come back to me. If you cut out the dead air between words, it'd be 3 minutes long. Jesus. Oh. Okay, so apparently that's her husband. Oh boy. Oh no. I'm not gonna sit and listen through any more of that. Like, I'm gonna give it a thumbs up though. I like this video. You got it, buddy. Keep working it. Keep working it. I support him. So here I am. I'm thinking this is definitely Melinda, but it turns out it's her weird husband or whatever. So I guess that's nice. Why would I hit dislike? I'm encouraging the man. I want him to do better. I should leave him a comment that says justice is a myth. You support him. Are you the state now? Oh, that's rude. That's very rude. Okay, let's do this Kyle Rittenhouse thing. Let's do this. Let's start this Kyle Rittenhouse thing. Like I said, I don't know if we'll get through all of it. I haven't watched this hearing yet. I did want to show you the sad body type of the judge. The sad body type of the judge real quick. So we'll watch him walk in so you can realize who is lording over us. David says, if you are willing, would you represent the rebellion with a convention of states? We can take back our country. Wait, what? Like, are you saying if we convened a convention of states to rewrite the Constitution, would I represent? Would I be a representative? Yeah, absolutely. Something tells me that I wouldn't be allowed to. All right, here we go. Check out this. Look at this sad body. Whoa! Look at that lady. Look at this. Look at this wide boy. Living off the fat of the people. Like, I want to point out, his head is minuscule compared to this chunk, this absolute unit of a man. It doesn't even look real. Okay. Really? Looks like Principal Strickland or whatever. This audio is really bad, but someone says it gets better. Okay. Let's see. I gotta find out where it actually starts. God, it's fucking terrible. I'll see if I can boost it in a minute for you guys. Just a second. This is great. This is the best TV ever. Okay, let me give this thing a little bit of boost. I hope there's no distortion on this, but we'll give it a shot. I gotta put headphones on. Ooh. Okay, here we go. Oh, wait. I'm sorry. I forgot to change it for you guys. Nothing's happening yet. You haven't missed anything. Judge is just whining about something. Okay, here we go. That,
Your Honor, as I indicated in my email, the state's position is that the jury does not need to hear from an expert to make a decision on the issue of self-defense here. The jury instructions are quite clear that it is what a reasonable.
Okay, so the first issue before the court is this issue of an expert. So Kyle's team wants to bring in a use of force expert who typically testifies on behalf of the popo when they shoot black people or whatever. That's a joke. Chill out, guys. I'll boost it a little more, and if they fix the audio, I'll bring it back down. But so they're trying to they want to bring in a use of force expert to testify that Kyle's use of force was reasonable, which makes sense, right? Like you want to have someone who is an expert in use of force come in and say, yeah, this is exactly what we would want someone to do.
Person would feel is appropriate, and I think we'll have a jury of reasonable people. There is no scientific, technical, or other specialized knowledge that will assist the jury in making that determination. So it was not our intent to have an expert on the issue of self-defense or use of force here. However, when the defense informed us that they were retaining Dr. Black, we responded twofold. Number one was to file a motion challenging Dr. Black, which is what led us to today's hearing. But we also retained our own expert, Bob Willis, who has spent the last couple months reviewing voluminous documents and all of the video and photos in this case, is in the process of preparing his report. As I indicated to the court yesterday in my email, he should have it by.
It's amazing what the prosecution will do is the prosecution is going to hire an expert who miraculously will say that somehow what Kyle did was not reasonable. And that's the funny thing about experts in expert witnesses in in these cases is that the expert witness for the defense will say that the actions were justified and reasonable. The expert for the prosecution will somehow suggest the opposite.
October 18th, and we will give it to everyone at that time, assuming the court decides on the other motion that expert witness testimony will be allowed in this case. I think it's also helpful for the court to give us some guidance in what the scope of those opinions will be at trial. For example, at the last hearing, Your Honor indicated that Dr. Black would not be allowed to offer an opinion as to the ultimate issue here, whether or not the defendant's actions were legally justified, whether a reasonable person in this circumstance would use deadly force. And I think that that's a very appropriate decision by the court. But I also think it's helpful for our expert, when he's working on his report, to understand the parameters of what the court will allow. So I communicated that to Mr. Willis, and he's going to take that into account when he's making his final opinion in the case. So I think that there are a couple of issues that need to be decided before we go any further. One is the motion that I've raised, which essentially argues that this is not something that either party should have an expert witness on, because the jury is well capable of making this decision on their own. And then second of all, as I said, maybe a little more guidance from the court as to the scope of the...
I just want to punch this fucking prosecutor in his fucking mouth.
Opinion that would be allowed to be offered by the experts. And as I said, I think the court has already indicated that the ultimate question is not one that the court will allow an expert opinion on. I don't know if the court intends to limit it any further than that, but certainly that sort of guidance will be helpful when we go forward.
Thank you. Did you want to respond, Mr.
Your Honor, I thought we were both going to be here to kind of test each other's experts a little bit today. I'm going to go first, get Dr. Black ready. Obviously, getting a report 2 weeks before trial, depending on what is or is not allowed, is we all had expert disclosure dates.
Actually, the minutes from the retrial of May 21st state defense to disclose their expert witnesses by 8/1/21. This includes filing of any expert report. What did that mean?
The defense would be doing it. Your Honor, if you'll recall, when we set these timelines, Your Honor, I did urge the court to give the parties a greater amount of time between that deadline and the trial date. I urged the court that 90 days was a very compressed time period for the state to respond to the defense expert by potentially filing a Daubert motion, retaining our own expert, etc. The court expressed confidence that we would be able to accomplish that all within that 90-day period. So that's where we're at today.
Well, but if you needed 90 days to address his, how come you're turning yours in on October 18th, which is supposed to be before trial?
I understand that, Your
Where
Honor.
did that date come from? I mean, where did that date come from?
My discussion with Mr. Willis, he indicated to me that he would be able to have it done by then. If the court...
So the expert reports were due a while back, and now the state wants to file an expert report on the 18th, and the judge is like, okay, why so late?
Would like it sooner, I can urge him to get it done quicker than that. But as I said, Your Honor, I did raise this short time period with the court when the court set these deadlines. I did urge the court to give us more time to get this accomplished because I was concerned that this compressed timeline would not give us a lot of leeway to get all this done.
Well, first off, on the subject of expert witness on the subjects that are discussed, I'm going to use Dr. Black's report as an example of this. And there are many points in there that I think are super effective discussed. I've been trying cases for 50 years as a prosecutor and judge, and
okay, so yeah, he's saying, he's reviewed, Dr. Black's report, and he says there's plenty of reasons to have an expert in this case, which is good. This is the defense wants expert witness, and they believe they have a good, credible expert witness that the jury's going to resonate with. And that's going to support Kyle's case. So it sounds like they're going to get it.
other things in there, at least what he says is factual, that I
Wow. David with a very big chat. Thank you. Says, honestly asking, and by accepting, you hereby accept the money as payment to figure it out. Convene the Convention of States. We hereby convene the Convention of States to limit the terms of federal representatives and reduce their effect upon our fundamental amendments. I'm up for it, buddy. I don't know how to make it happen. But I think, the more we talked about this on, was it on Flashcast? It was on Flashcast. We talked about this. The divide in this country, about more than half of Republicans and almost half of Democrats want a literal split of the country. They want to break into multiple countries. We're getting close to an organic convention. I mean, if this shit keeps up and the unrest keeps up, there's not going to be much other options. We're going to have to do something. It's going to get to the point where people need that valve to pop, right? And the steam has to release because we're in a fucking pressure cooker. I don't know if it's going to be, this a split of the country. I don't think that's going to work. But that doesn't mean that we're not pushing towards like a very radical shift in how things happen. So maybe. Thank you for the very large chat, buddy. I'll let you know if I can. If there were something to do that, I would happily participate. I don't know what I could do for it, but Mither and Emrys says, "Good Lord, are they recording the audio with a mic placed outside the courtroom? And can this prosecutor please make a point in 100 words or less?" I hate this prosecutor. I hope he catches some very irritating like fungal disease or something. Nothing that would kill him, just would make him feel bad. Blainstorm says, "My masseuse was a wide boy, and his sausage fingers and bone elbows coming from his honey-baked biceps were perfect. Lots of gravity helping. Only negative is coming face to gunt with male camel toe when he scooted too close." No! Gross. Oh, did you guys... Real quick, I made a new Streamlabs avatar. And you probably didn't see it. So I just wanted to show you my new Streamlabs avatar real quick before we move on. There it is. It's Guntcat. Guntcat is my new Streamlabs avatar. So just so everybody knows. That's so I'm not using the Streamlabs right now, so it's not as easy to pull up. So I had to pull it up separately. But yeah, there you go. I worked really hard on it. Fucking stupid Ralph. What a dummy. David says, very well. Article 5 of the U.S. Constitution gives states the power to call a convention of states to propose amendments. It takes 34 states to call a convention and 38 to ratify any amendments that are proposed. Yeah, it's not a question of like that. The process exists. The question is getting the 34 states to actually call the convention. No one nowhere says, didn't Streamlabs ban you? Yeah, my StreamYard avatar. Did I say Streamlabs? I meant StreamYard. Okay, let's get back to this shit fucking audio courtroom.
That could be useful to the jury in reaching the case. I even have given additional thought to the question of opinions on the ultimate fact, which are purpose around the law. what I thought I was attempting to do, I think actually was, well, what is the law, and what I think I could read was that as to what constitutes self-defense, that instruction will come from me against the law, and not from something else. But whether, when applying that, the evidence that Dr. Black or Mr. Willis, is it Dr. Willis or Mr. Willis?
Mr. Willis.
Mr. Willis. May part may be sufficient basis on which to commit.
Wait a minute. Let's go back just a minute here. Just a couple seconds.
Mr. Willis.
Okay, so use of force expert for the defense is a doctor. Use of force expert for the prosecution is a mister. Why even bring him?
May part may be sufficient basis on which to commit an opinion on health. In fact, I'll have to decide that down the line. But certainly in terms of defining what constitutes reasonable force, whether there's a self-defense, on what circumstances self-defense exists, those are legal issues that I'll have to tell the jury about. Shame on me for not getting some guidelines on this, because I assume that this expert report will have to deal with that down the line.
Shame on me, I guess. Riveting, Judge.
Use of force expert, and well, I was thinking about it. You say there's no necessity for it, but unless my memory will serve me, I know it doesn't. Your office has been using use of force experts. You used it in the Jacob Blake Chesky shooting.
Oh shit.
You used it in the shootings.
Okay, so the judge is like, now, if I'm not mistaken, you say that use of force experts aren't necessary, but you've been using them in these other cases, right? So, like, why is it good for you, but not good for Kyle? Like, why do you get to use of force experts in these other cases, but not here? Oh, that's a good fucking question, isn't it?
There's a different standard for police officers than civilians.
Well, I agree with you there. Well, I don't want to say that. There may be, in certain instances, we'll have to apply that as the situation develops. Evidentially. In the end. But regardless of that, I mean, there was a lot of content in Dr. Black's report.
You guys still can't hear? I boosted it a lot. I know it's really fucking quiet. I've got 20 decibels of gain added to the output here. It is really hard to hear.
That was certainly, and he recognized that in his report would be applicable to an ordinary citizen, particularly ordinary citizen, Rittenhouse. So
I think what the court is referring to is that there have been situations in which the district attorney has had to make a decision as to whether or not a police officer's use of deadly force was justified or not. That is the legal responsibility of the elected district attorney, such as Mike Gravely, in the shooting of Jacob Blake by Rustin Chesky. The evaluation in that process considers the training, the protocols, the guidelines, the rules, the handbook that are set forth for promotion police officers, and how those were applied by that officer in that situation. So when I talk about a standard, and I think Dr. Black's expertise is largely in this area of...
Mithrin Emrys says, the state doesn't have their report ready from their use of force expert. Shocked, I tell you. It isn't like they weren't aware that the defense would call in a use of force-based case. Give me a break. And they knew. They've known that they were going to bring a use of force expert since at least August. Since at least August, they knew a use of force expert was coming. And remember, this shit happened, what? Well over a year ago. They've had plenty of time to get a use of force expert. Now he's saying it's different though, because in police cases it's different than in other use of force cases. When in actuality, it really isn't different. It really isn't different. Police use of force in Wisconsin is the same as regular person use of force. Is there imminent risk of death or serious bodily harm to someone from the person? If so, then the use of force is justified. Stagus, check DMs where? On Discord? Okay. But I have to figure out where the fuck we are to do this. Let me see.
All right, this is the case of the state against Kyle Rittenhouse.
Yeah, that's way better. Hold on, I probably got to turn the gain back down on that. Okay, give me a minute. Let's find
the ambient gunfire, things like that. That stage can be set. This is not that type of case. The jury is not...
Report available in making a prosecutorial decision. Why would it be inappropriate for this kind of evidence to be utilized by the jury?
Because there's a different standard for police officers than civilians.
Well,
this is really close to where we were, so this is found. This is it. Sorry. Sorry for killing you with the massive decibel increase. Hopefully you didn't die. It's still too loud. It's still too loud.
I agree with you there.
Oh shit, it is.
Well, I don't want to say that. I don't want to say that. There may be, in certain instances. We'll have to apply that as the situation develops. Evidence in the evidence. But regardless of that, I mean, there was a lot of content in Dr. Black's report that would certainly be, and he recognized that in his report, would be applicable to an ordinary citizen.
Who the fuck is Bob? Hey, what up? I'm Bob.
Particularly the ordinary citizen, Kyle Rittenhouse. So
I think what the court is referring to is that there have been situations in which the district attorney has had to make a decision as to whether or not a police officer's use of deadly force was justified or not. That is the legal responsibility of the elected district attorney, such as Mike Gravely in the shooting of Jacob Blake by Rustin Chesky. The evaluation in that process considers the training, the protocols, the guidelines, the rules, the handbook that are set forth for Kenosha police officers, and how those were applied by that officer in that situation. So when I talk about a different standard, and I think Dr. Black's expertise is largely in this area of whether or not a police officer followed the training and the rules and the guidelines set forth by their department that govern use of force. We don't have that here. Mr. Rittenhouse is not a law enforcement officer. There are no guidelines or rules that he's expected to follow. He's an ordinary citizen. And so the basis for my motion was largely that, and I think the court has hit the distinction right on the head. If we had a jury that needed to be educated as to what the law enforcement agency's guidelines were, what is reasonable adherence to those guidelines, what may be considered excessive or a violation of those guidelines, Dr. Black would be one of those people that could tell the jury about that, at least for the law enforcement agencies he's familiar with in Oregon. But this is not that type of case. The jury doesn't need information about that. The jury is no different than anyone in terms of a reasonable person. These are going to be the people that we're going to bring in off the street, who are going to serve as jurors, who are representative of our community, and they will make a decision as to what a reasonable person should have done in Mr. Rittenhouse's situation. They are in as good of a position as Dr. Black or any expert to make that decision. They have
I strongly disagree, and this guy knows that no juror is anywhere near a reasonable person. Jurors are the worst. Random Blaze says, did you see that the baby that caused the Roe versus Wade decision may have not been aborted, Rackets? Oh, it definitely was not aborted. Someone came out claiming to be the child. Gateway Pundit has a story about it. If true, would this vacate the decision? No, they knew that the baby was born. That was part of they tried to moot the case. And the Supreme Court said it wouldn't be mooted because it would never get through a Supreme Court case before the baby would be born. So no, the Roe baby was definitely born, and yeah, but that won't change Roe versus Wade. Mither Nimmer says, wait, did he seriously just say the police have different standards than civilians? No, but if there were a difference, police would have a higher standard, and an expert could explain that to a jury. Oh. Yeah. Zyver Warrior says, screw you, I was a juror and I was great. You're in this chat and you think you're a reasonable person? I've got news for you.
All of the requisite knowledge they need. I understand the court's point about Dr. Black's report, and I see some information in there that can be developed by counsel on cross-examination. The stage can be set by witnesses in terms of the scene that night, the circumstances, the darkness, the fires, the ambient gunfire, things like that. That stage can be set through other witnesses, and then counsel can argue to the jury as to what effect that might have had on a reasonable person, such as a person in Mr. Rittenhouse's situation. But we don't need an expert to talk about those things because they're basically common sense. We're talking about nighttime being dark. We're talking about the effect of gunfire. We're talking about the effect of crowds.
Common sense. You don't want common sense, homie. You definitely do not want common sense, because if you're being chased by a pedophile, who's ranting and raving and throwing shit at you, the common sense solution is to put the fucking bullets in every body part you can hit. Yeah, you saw him almost call Rittenhouse a reasonable person. Had to try and walk that one back quick. He's like, oh, fuck. Guys, I hate this prosecutor.
These are all common sense things that I think reasonable people can understand. And so I think the court's distinction is an important one, because this is not those types of situations or examples the court mentioned. This is not where we're talking about a law enforcement officer's compliance with the procedures set forth by their department. So,
Mithran Emrys says, for fuck's sake, the point of this motion is for the state to eat up more of Kyle's defense fund on this idiocy. Having to write the motion and appear in court for the hearing took tens of thousands from that fund. Oh yeah, a complete waste. Plus you've got a 3-hour appearance here, 3-hour appearance. Plus, yeah, you've got the motion paperwork going on, and they really want them to have paid John Black here and then not let them use him. They want to drain Kyle's resources. But of course, an expert makes sense in this, and you should be entitled to an expert for your defense. And I'm pretty sure the judge is going to allow the expert, but I don't know. I haven't actually found out what the answer is on this part of the hearing yet. Don't you dare get me to 1,000 likes, because I'm trying to not drink. So there.
that's why I think the examples you mentioned, Judge, are not applicable to this case. And I would further indicate that there have been other cases in this court and others, and I would turn the court's attention to a Mark Carver case a couple of years ago. The court may recall that was a case in which there was a road rage incident, and the defendant got upset with another driver, went over and confronted that driver with a knife, and stabbed the other driver. The other driver was unarmed. The other driver had punched Mr. Carver prior to the stabbing. This court didn't even allow a self-defense instruction in that case. And this court obviously didn't allow an expert witness either, because...
I mean, it's pretty fucking different. Like, it's pretty different. Like, can you believe this guy? Here you guys are. Oh, here's 1,000 likes. You better drink, you boomer. You're stuck to our will. You don't even get to live your own life. You're out here trying to live your best COVID life and just die with dignity. No, you get to die drinking. Fine. Cheers.
Those were things that could easily be understood by a jury. Judge Wagner had a similar case.
Wait a minute. If I didn't allow a self-defense instruction...
You're right. I misspoke there. You're right. But my point is that there wasn't there weren't factual circumstances there that would have necessitated a self-defense instruction in that case. Judge Wagner recently had a case, Timothy Carson, which was a case in which a Bradford student had stabbed another student in a classroom, an unarmed student. And the court held hearings in that case and ultimately decided no expert witness testimony would be necessary there either, because the jury was capable of understanding self-defense concepts without any scientific, technical, or other specialized knowledge. So I think when you're talking about the examples you set forth...
Let me just say, I interrupt you for a second. When I was practicing law, and I would sit there at that very table, well, actually, most of these prosecutors sat on that side, but, and judges would make rulings, and I'd be sitting there and thinking, where is this guy coming from? I think that's clearly either, admissible or not admissible. And then I got up here, and even for a period of years, my mind did not change on that. But it gradually sunk in what I had been taught long before. The judge has enormous discretion on evidence. I don't think most lawyers have an appreciation of that. I think a lot of lawyers, it's a black and white. It's either is admissible or it's not. There's huge areas where there's enormous discretion. So what Judge Wagner did in a particular case, whose facts I have no knowledge, is absolutely no precedent for me. And in fact, I'll tell you one more story. And of course, I've always got a story.
It's a funny thing. We talked about this with Judge Chump ruling on the COOF case, or the mask case down in Texas. it's not always the best idea to say, well, the other judge did this. Especially because this guy is the longest serving judge in Wisconsin, I think. He's been a judge for 50 years. Like, this guy, I mean, this guy's been judge a long time. And it's just not the best plan to argue. This guy looks completely fake. Like John Black here, he looks like a robot or like an AI from like a 1998 movie. And it's like he's gonna be like, "Hi, let me tell you about." Like, can you? I just expect him to do that, like that Max Headroom shit. It's weird, but yeah, this. Telling the judge that some other judge didn't allow an expert in some case is just not a good plan in general. It just doesn't end up working out. Bad Vibe says the judge needs to flush this turd. The prosecutor is a floating stinker.
When I first, this is part of my learning process that I was just mentioning. I went to one of my judicial education programs, and there was another judge there from west part of the state, and he talked about a case that he had tried and how he had made an evidentiary ruling on a particular point, and he was appealed, and he was reversed on other grounds, but he was upheld on the particular evidentiary ruling in question. Because he was reversed on other issues, it came back for trial, and the second time around, he said the exact same evidentiary issue, and he ruled the other way. He said, I looked at it differently, and I decided to make the opposite ruling from what I made the first time. He was appealed and affirmed on that, too. So that's a judge who made two totally inconsistent rulings, which were within the spread of his discretion, and was affirmed on both of them. So that's illustrative of the judge's discretion on these things. And as I say, as what Judge Wagner may have decided in another case with whose facts I'm not familiar. Number one, I'm not familiar with the facts, and number two, Judge Wagner and I could be sitting up here next to each other, and we'd talk about it, and she'd go one way and I'd go another. So I get what you're saying, but go ahead.
I'm finished, Your Honor. Thank you.
All right, Mr.
Your Honor, the court, I wrote down, I don't have the institutional knowledge that maybe Mr. Binger has about all the Kenosha County cases, but the one thing I wrote down is they have no precedential value. The court said that. These under the expert under 90702 is going to be decided by this court, which has great discretion in what it allows and doesn't. The most recent case from the Wisconsin Supreme Court was State v. Dobbs. That case was, I think, different than this case because in that the expert didn't apply facts of the case to what he wanted to testify, and it was excluded on those grounds. The standard is very low. Will it aid the trier of fact in the determinations at hand? And I believe that Dr. Black is qualified. We can put on that offer of proof. We have his CV and his report and the facts that we wish to elicit regarding it. I believe that under the circumstances of this case, it would have a great aid to the trier of fact.
The trier of fact is the jury. Just so everybody's aware, if you don't know, that in a jury trial or in a bench trial, the job of the jury or the judge serving as a jury is to determine what are the facts. And then those facts are applied to the law, is the idea. That's how the verdict is rendered. So it's their job to determine what they believe to be the factual story based on what's presented to them in court. that's a hard thing to remember. It's a weird distinction with how this court process works. But it's not just like, does the jury think they're guilty? The jury isn't actually supposed to make legal determinations. They're supposed to determine whether the facts as presented fulfill the sort of like a checkbox for the law in question. So in this case, did Kyle Rittenhouse like shoot the person, right? Like, did he shoot a person? That would be the first degree, did he do it with the requisite intent to be first degree murder? Do the facts measure up to that? But then the next part would be, did he do what a reasonable person would do for self-defense, et cetera, et cetera. If they did, if that measure, if they determine those facts, like, then they apply them to the law afterwards. But their job is to figure out what the actual facts of the case are. Because there's two stories, right? There's the prosecution story and the defense story. And they have to suss out what the facts are between them. If there are no facts, if there's no material issue, a genuine issue of material fact, then the jury has no value. So just clarifying that.
Ready to rebut or attempt to rebut whatever Dr. Black says with their expert who was recently named. But when Dr. Black testifies, he will testify that he did this evaluation not from a law enforcement standpoint, but the citizen standpoint. And that was one thing when I engaged him. I didn't want a bunch of law enforcement mumbo jumbo. I wanted things to look at the eyes of a 17-year-old in a very chaotic evening on August 25th in Kenosha, and that's what I think he can bring to bear in this case.
Thank you. All right. Well, I am going to open the door to the testimony of Mr. Black, or Dr. Black, rather, after I hear the presentation by the state, and then also to that of Mr. Willis when I have more information about that, and we'll see what can come in and what can't. So that's one issue. There was an issue you raised in an email yesterday about microphones on the table, and I will tell you that I believe that the media, I know that the media has been told they have to get their audio feed from the audio system here in the court. Does that make sense to you guys? Okay. So no additional microphones will be permitted anywhere in the courtroom. If anybody's taking videos out there or recording, that's not permitted under the court rules. So please, you must refrain from doing that, other than the 3 cameras here and the 2 stills over there. And there actually are a variety of good reasons for the rule, which I'm not going to get into. You had also had you had an issue about witness anonymity. Well, actually, beyond that,
Music. Music.
Well,
What music?
Go ahead.
Your Honor, the court is well aware that there's a lot of attention on this case, and some of that attention is of the harassing or even threatening variety. The court has made some rulings in the past with regard to that. We understand that this is a public case. We understand that there's a right to confrontation. We understand that witnesses' names are going to have to be disclosed publicly. We understand all of that. Counsel and I have had some private discussions regarding the exchange of addresses of witnesses. I think we are in agreement that, generally speaking, addresses are going to be kept between the parties. We haven't put them on publicly filed witness lists because of that concern. But I think all the addresses that are needed among the parties have already been distributed. The concern that has been raised by some of the folks that we've talked to who are witnesses in this case is that their images, their photos, their face would be shown on TV.
Gee, I wonder why they'd be concerned. Is it because the witnesses that you're going to talk to are all Antifa rioters. They're all Antifa rioters who spent their time burning the fucking town to the ground. Gee, why would they be concerned about showing their faces in public? Huh. Very strange.
Pictures would be taken of them and published, etc. And that has its own level of intrusion and concern in terms of safety and threats and harassment and things like that. I understand that this is not a common request, but this is also not a common case. Most trials that I've done in this courtroom before Your Honor, nobody in the gallery has been here or even paying attention, so it's never been a problem. But this is a case in which there's obviously a lot of attention. So on behalf of some of the witnesses that I've talked to, I informed them that I would raise this issue with the court, that I would express that concern, and I would see if there's a way that with certain folks we can place a limit on photographs or video taken, or somehow arrange it so that their images are not shown publicly to the outside world. I understand folks sitting in the gallery will see them. That's something we can't control. But being broadcast over TV or video or published in the paper, things like that, there may be a couple of witnesses that are very uncomfortable with that. And I wanted to raise it with the court on their behalf. And obviously the concern I have is for their safety, and I just don't want to put anybody at risk. So I want to raise that for discussion with the court.
Mr. Richards?
Your Honor, I don't have a position really one way or the other. The media is trying to do its job. I just want the people to be here to testify so my client can get a fair trial. I'm always afraid when people start talk about amorphous threats and things like that. You know, I don't know who Mr. Binger's talking to or who's making these requests. I know that many of the people who are listed as witnesses have incredible social media presence that they put out there and put themselves out there as a witness. One of the individuals, I won't name him because of what we're dealing with here in the court, you know, he announced he'd been served with a subpoena, was looking forward to testifying and other things. He put that out under one of his names. You know, we're monitoring social media. And so I don't know where these threats are coming from. I don't know who's receiving them. So
Nobody's receiving the threats. You know they're not. They're not getting threatened. Prosecutor's just a piece of shit. He's just a piece of shit.
I really don't know how to respond. I just want to have a trial. I don't want people to be masked, you know, or covered up. What the court rules in regards to the media, that's above my pay grade.
Thanks. I would tell you that to the extent that I have any authority over this at all, and I'm not sure how much I would have, that would be very case specific. It would have to be witness specific, particular person, and the level of discomfort that the witness may have is, if it's relevant at all, it is only marginally relevant, because that's not the test. If there's a legitimate security issue,
there isn't.
That may require some degree of scrutiny, and I have, in my experience, has been, and although this case is probably the most publicized case I've ever had, I'm not at all clear that it's the I could list quite a few cases that I've had and other judges have had here that I would say the tension level would be higher. This case happened to get into a political, we've talked about it before, and it got hyped up. I'm not trying to minimize it's the importance of the case, and certainly it's definitely important to all the people involved. But in terms of the degree of attention it's gotten, I do think that some of that is due to
come on, Bruce.
No, they wouldn't have occurred in ordinary circumstances, but it happened in a a very tense period otherwise. And I certainly understand that there's some degree of fear that people have. As I pointed out in my letter, however, about on the subject of the questionnaires, from my estimation, based upon my years in the courts, and I think many of my colleagues would agree with me, there are other cases that come in here where there is much more reason for concern, particularly for people who are residents of a neighborhood where most of the witnesses may come from, that is under control of various criminal elements. Not, control is the wrong word, at least in Kenosha, but where there's really a scary situation for people, and that needs to be addressed. And my experience, the media has been pretty responsible. I've never had a problem, and I don't go to the media and say, can you do this, can you do that, in terms of censoring, but generally discussing some of the issues that you are mentioning. I have experienced great cooperation over the years. Oh
my gosh!
I'm certainly not going to make any overture to anybody about covering this case any differently from any other, but that occasion could arise, in which case you should bring it to my attention, and we'll talk about it then.
Thank you.
All right. Now, let's see. What was next? There were a few other things before we start the Daubert.
I think one of the things that's kind of hanging out there is a brief regarding the possession of the firearm by a 17-year-old.
I knew there was something. And yes, I worked on this. Yeah, go ahead.
Mr. Sharafi's handling that.
Oh, okay. All right. This is your motion, Mr. Sharafi, so you can be heard.
Thanks, Judge, if you can hear me. So I don't have a whole lot to add to the motion. I have read the response filed by the state in Mr. Black's case. And
Okay, so this is the motion to dismiss the minor in possession charge, which I have maintained the entire time. Kyle is not guilty of minor in possession because the law does not apply to 17-year-olds, except when they are in violation of either having a short-barreled rifle or shotgun, or are in violation of not having the proper hunting permit requirements fulfilled. Since Kyle is not hunting, other than pedos, since he is not deer hunting or whatever, he should not have that requirement. So this is the motion on that.
in reviewing it, what we're asking is the court just do a review of 94806 sub 3 sub C.
Thank you.
Do I have to? That's not a very difficult statute to work with.
It is. However, I think it's easy to cut through this portion of it. The first part applies to people who are armed with a short-barreled rifle or shotgun. I don't think anybody's making that allegation. So, Your Honor, our position is sub 3 sub C, as it states in the plain language, applies only to a person under age 18 if that person is not in compliance with 29304 and not or and 29593. I would submit to you, Your Honor, that when you read 29304, it is the name of the statute is restrictions on hunting and use of firearms. So it's not simply a hunting statute, as Mr. Binger has set forth in his motion. It is also on restrictions on possession of a firearm by persons under 16 years. By definition, Mr. Rittenhouse at the time does not qualify under that statute. This statute does not apply to him. He was 17 at the time. And sub A of each portion of that subsection. So for example, 29304 1A is a prohibition on hunting. He's right on that. But 29 sub 1 sub B is a restriction on actually the possession of the firearm. And that is true for sub 2, which talks about persons 12 to 14 years old. Sub 2 sub B is restrictions on possession of a firearm for a person 12 to 14. And sub 3 of that 3 sub B is restrictions on possession or control of a firearm for persons 14 to 16. There is nothing in 29304 which would be a prohibition on a 17-year-old possessing a firearm. Nothing. He cannot, it is impossible. And the way that the state is saying this is they're saying, because he's 17, he can't be in compliance with that statute. So what that means is this, to take this to Mr. Binger's final conclusion, a 13-year-old can possess a firearm under this statute. There are ways they can do that. A 13-year-old can possess a firearm if they're in the accompaniment of an 18-year-old. But under no circumstances would a 17-year-old be able to possess a firearm. That makes zero sense. That the legislature would write a statute that allows a 12-year-old to have a gun, a 13-year-old to have a gun, but a 17-year-old can't have a gun. It makes zero sense. So what we believe is
why would they have the general proscription of the law in 2A that says any person under 18 who possesses or grows armed with a dangerous weapon is guilty of a misdemeanor if your interpretation is sound?
Well, if 3A, Your Honor, talks about who it doesn't apply to, right? So it doesn't.
Because there are all sorts of dangerous weapons that are not long-barreled rifles and long-barreled shotguns. That's why. That's why. Dangerous weapons, nunchucks, brass knuckles, various swords. These are all laid out. A taser, handgun. These things are all not excluded from the statute and are included in the dangerous weapon definition. That's why they have the statute. They don't want a bunch of 12 to even to 17-year-olds running around with handguns, because handguns are viewed differently than rifles and long-barreled shotguns. That's why. They wrote this statute. They revised this statute in, I think, 1992 because of gangs in Milwaukee, frankly. Like, that's why they did it. They wanted to stop handgun. They wanted to be able to charge these young kids running around Milwaukee with handguns, but they didn't want to be able to charge a bunch of, country kids in Wisconsin, which is a heavy hunting, favorable state, right? Like they wanted to preserve the hunting mentality of it. They just don't want a bunch of kids running around with handguns in the inner cities, period. That's why it exists in this way. And I wish he would have said that. I don't think he's going to, but
doesn't apply. Yeah.
Well, the exception, as you're looking at it, swallows the rule of 2A. Now, the legislature does. There was a point. It's got to be 20 years ago now when on the same day they passed two conflicting pieces of legislation. So they got a busy job up there, and they have they get into sessions where they're passing laws. Speaker Pelosi talked about, well, we'll read it, and this is Congress, of course, but we'll read it after we pass it. And that seems to be sometimes the attitude. when you've got two conflicting statutes passed on the same day. But I was looking at the rules of construction again last night, and sub A, I think, sets forth the general policy of the law that person under the age of 18, with limited exceptions, which are not so well stated in sub 3, is not to be out and about with a dangerous weapon. Go ahead, I interrupted you.
No, I agree. I disagree with this, Judge. I don't think that sub 2A is swallowed by the exceptions. And the reason I say that is a 13-year-old who is walking the streets is guilty, period. They are guilty because they don't fit within one of the exceptions of 29304, period. They do not. So it doesn't swallow the rule. Each one of those sub 1, sub 2, and sub 3 are all age specific up to 16, and they all set forth restrictions on people not hunting only, but hunting and then simply possessing a firearm. So I disagree that it swallows the rule. There are clearly situations in which no 12-year-old can have a gun, Judge, period. That's what the statute says.
Why would they put the word 18 up there then? Why did they put in the word, why did they say 18?
Well, I don't know.
Because the dangerous weapons are the motherfucker fucking. Because dangerous weapons is a broad term that includes a whole bunch of shit that are not long-barreled rifles and shotguns. That's why. That's why. It's in the fucking law. Bad Vibe says, this judge is fairly even-tempered. I feel sorry for the person that pushes his limits. There isn't a fan big enough for what it will hit it, but I think the prosecutor will see it. This is infuriating. Again, I think he's making the argument too complicated. Judge, because outside of the restrictions, which don't include short barrel rifles, right? Handguns are a dangerous weapon. We don't want a bunch of kids running around with handguns. But rifles are different, Judge. You know this. Hell, Judge, when you were 13, you had to have a rifle to fight the British. Judge, so you know the importance of this.
Not positive I can answer that question either.
Oh.
But what it appears to be from a plain language of 3C is the section only applies if you're under 18, have a short barreled shotgun, or rifle, which he doesn't, and are under the age of 16, according to 29304. He doesn't. He doesn't fit under that statute. And it is not simply a hunting statute. It is a restrictions on possession of a firearm statute. So I can't see it because his age is not mentioned. It is not mentioned anywhere in 29304. There is no subsection of that which applies to him. None. So I understand it's not a well-written statute, but there appears to be exceptions for 17-year-olds. And that's what he was at the time. There is nothing limiting restrictions on possession of possession or control of a firearm under 29304, which is an exception to sub 2 sub A, which the court has talked about. So from a plain reading of it, it doesn't, he's not in violation of that statute. If he was 16 or under, he could be. But because he's 17, he cannot be. That's correct. Our argument.
That's actually, it's a correct argument.
I think what the defense is missing here is that Chapter 29 of our Wisconsin state statutes is entitled Wild Animals and Plants, and every subchapter deals with hunting, trapping, fishing, commercial activities, fees, education, game wardens, etc. That chapter sets forth many of the rules and regulations that apply to hunting and fishing in the state of Wisconsin, which is something that is a proud tradition of many Wisconsin residents and is a very substantial industry in our state. The Wisconsin legislature, when they drafted 948.60, established a blanket prohibition that if you're under the age of 18, you can't be running around with a gun. That's
Wrong.
the general rule.
That's not the
And
rule.
what we have in this case is clearly a 17-year-old running around with a dangerous weapon.
I'm so fucking mad about this. All right. Let's take a peek at this. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor, except 3A. This section does not apply to a person under 18 years of age who possesses or is armed with a dangerous weapon when the dangerous weapon is being used in target practice. Or wait, no, we want to go 3C. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun. If the person is in violation of 941.28, that's the long-barreled or the short-barreled rifle or shotgun. See, like, this is what he has, this is what's so fucking infuriating. Or is not in compliance with 29.304 and 29.593. So there's a specific carve out if it's a rifle or shotgun, which he clearly has a rifle. There's a reason there's a carve out. Again, handguns are different because little gangsters use handguns, not rifles. The section applies only to an adult who transfers a firearm, blah, 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 blah. I don't know why he did not cover the fucking language that says, yeah, Your Honor, it's a specific carve out for the rifle or shotgun wielding under 18-year-old, which obviously Kyle falls under.
This case is a perfect example of why we don't want that happening, because 2 people died.
Oh, yeah, he would have been much happier if just Kyle died. Fuck you, prosecutor. Get fucking wrecked. Not the other R word.
Now, in recognition of our strong industry of hunting and fishing and trapping, etc., there were some exceptions carved out. And those exceptions are set forth under sub 3A, B, and C. I think those should be construed narrowly. I think the court is right that those exceptions are not intended to swallow the rule.
They don't.
And the defense interpretation of sub 3C would rewrite the law to say that if you're under the age of 17, you can't possess a dangerous weapon.
They literally do. It literally says that. That's what Corey there, Kyra Feces is pointing out. It literally says if you're under 17, because that's what the law actually says when you've got a rifle or a shotgun and not a handgun.
But that's not what it says. It says
that
18.
is what it says.
The defense
Fucking
interpretation
liar.
would allow any 17-year-old to run anywhere in our community, our state, with a dangerous weapon.
No, only with a rifle or a shotgun. Period. Not any dangerous weapon. Only a rifle or a shotgun. Because it's only in the fucking statute.
That's clearly not what the statute allows. Counsel says the defendant can't comply with 29.304. Well, none of us in the room can. It doesn't apply to us. So he's not violating it. He is in compliance with it. It doesn't apply to him. However, 29.593 does. 29.593 sets forth requirements for a certificate to be allowed to hunt. Now, At trial, the state will put forth evidence that the defendant was 17 on August 25th, 2020, and had a dangerous weapon. If the defense, in their case, wants to establish that one of these exceptions applies as an affirmative defense to that charge, they can submit evidence that the defendant had a certificate to hunt and that he was engaged in legal hunting activities on the streets of Kenosha that night.
You're such a fucking liar. I hope you get gonorrhea right in your fucking mouth. Aho says, hope you get better. I've been sick with COVID for a month, glued to bed. Wasn't fun and nearly got let go. Lol. Yeah, it's shitty, man. It's shitty.
I don't think they're going to be able to do that. But that's the way this would play out. And I could see a circumstance in which maybe in a more rural community, that might be a situation where a 17-year-old is running around hunting and they're charged, but then they establish compliance with these other statutes. And that may be
He wasn't hunting. He has no reason to be in compliance with a hunting statute.
a debate in that case. It's not going to be one in this case. The defendant wasn't hunting deer. He wasn't hunting turkey. He wasn't hunting wild game. He didn't have any certificate or training to do so. He was not in compliance with the hunting statutes, which are set forth in Chapter 29. So, Your Honor, the defense interpretation here, as the court has rightly pointed out, would swallow the entire statute. It would establish a precedent that 17-year-olds can run around with guns, which is clearly not what the legislature wants. It's clearly not what the law says here. And so the count in the complaint that charges the defendant with possession of a firearm under the age of 18 is an appropriate criminal charge against the defendant. I believe the evidence will show he's guilty, and I don't think the defense will be able to establish that any of these exceptions apply.
Well, this would not be, if the purpose of the legislation was to neuter the statute itself, it wouldn't be the first time the legislature did that either. They sometimes do pass exceptions that follow the rule for whatever reason, either by design or by oversight. And
someone asked for the link to the subsection. You can see it here. There's there's the link to the subsection. This is the most infuriating shit on the planet. Because Kyle is not hunting. There's no obligation to have a hunting permit to carry a gun. Again, rifle or shotgun. If the person is in violation of this or is not in compliance with this, but he's not hunting, he doesn't have to. He doesn't have to comply with it.
If legislation gets passed without knowledge of what's in there, that it would be easy to do exactly that. I'm going to deny the motion for now, but I'm going to. That's no guarantee I won't re-examine this. I just don't. I don't feel comfortable. It's a penal statute, and to hold people accountable for laws that, the basic rule, and there's plenty of interpretation on it, but the basic concept of the rule is that it has to be clear to ordinary people. And if you've got, judges spending hours here and hours or more at an appellate level trying to figure out exactly what the statute says, how does that serve the people?
It doesn't serve the people, but so the judge has denied the motion to dismiss, but he's left it open. So they need to file supplemental briefs on this. And they need to clarify, I guess, they need to clarify that the dangerous weapon statute does not apply to rifles and shotguns. Like that is the specific carve out of Section 3C And that is why Kyle falls directly under this thing, is this specific carve out, and that he has no reason to comply with a hunting statute because, again, if we go here, he's saying he didn't comply with this statute. Requirement for certificate of accomplishment to obtain hunting approval. So, except as provided, no person born after January 1st, 1973 may obtain any approval authorizing hunting unless the person is issued a certificate of accomplishment. It's issued for a person for successfully completing the course under the bow hunter education program, only authorized to obtain a resident archer hunting license, non-resident archer hunting license, a resident crossbow, or a non-resident crossbow license. Person who has a certificate, license, or other evidence that is satisfactory to the department indicating that he or she has successfully completed in another state, county, or province a hunter education course recognized by the department may obtain an approval authorizing hunting. Person who has a certificate, license, or other evidence that is satisfactory to the department indicating that he or she has successfully completed in another state, country, a bow hunter education course recognized by the department may obtain an archer hunting license or crossbow hunting license. Person who successfully completes basic training in the U.S. Armed Forces, Reserves, or National Guard may obtain approval authorizing hunting. Person who is subject to Subdivision 1 may prove compliance with Subdivision 1 when submitting an application for an approval authorizing hunting by presenting any of the following: his or her certificate of accomplishment issued under this, an approval authorizing hunting. See, here's the thing. Kyle is actually not in violation of this statute, because to be in violation of this statute, you have to hunt without approval. You have to hunt without having authorization to hunt. But Kyle wasn't hunting. Notice what none of this statute says. None of this statute has anything to do with guns. Nothing. Nothing in here has anything to do with guns at all. That's what makes this so fucking infuriating. Is that he has no reason to be in compliance with that statute. He's not out of compliance with the statute. He didn't shoot a deer without authorization. He didn't shoot a turkey or a pheasant. He didn't do anything like that. There is no failure to comply with the statute. Rob Stratton says, how does one demonstrate compliance with 29.593 when it's not even relevant? I guess he would have to show that he got a hunting license, but it doesn't make any sense because he's not hunting. So he's not in violation. He's not in violation of the statute. Again, here's what it says. Or is not in compliance with this. But he is in compliance because he has not engaged in hunting. So he does not need hunting approval.
So I'm going to deny the motion subject to reconsideration. Without motion, I want to give more study to this. And I believe me, it's not because I haven't looked at it extensively at this point. All right.
Would the court accept, we have some legislative history that I think either makes it better or makes it worse. Would the court, would the court be interested in looking at that?
I have looked at some, but if you've got something that perhaps I haven't seen, whatever, yeah.
I didn't want to get too far into a field.
Yeah, no.
We will provide it.
Okay, so Mark Richards there says, we've got legislative history that shows this, and the legislative history is probably them going to say something along the lines of, look, this was made for inner city kids. This is why the legislature changed this in 1992, because they were trying to stop rampant handgun violence in metro areas in Wisconsin without having, the regular sort of traditions of hunting and stuff being implicated in this. That's what the legislative history is probably going to say, if I had to guess. And it's also true. It's also fucking true.
I'll obviously copy the state on it.
All right, but for now it's tonight.
Understood.
All right, now, do we have anything else besides the Daubert?
I don't believe so.
All right, so go ahead, Mr. Richards. Go ahead.
Attorney Richards would call.
Okay. I think this is where I'm going to stop the video for now. I think this is where I'm going to stop the video for now because it's 1:15. I got to read through super chats and wrap up. I got to get some sleep before the Sargon interview tomorrow. Woo. And then we will resume this probably tomorrow night. We've got the Daubert hearing, which is they're going to qualify the expert witnesses. So, which taught you being more patience, being a lawyer, or being a parent? Neither one of those are good for patients. Oh my God. Both of them make you want to throw everything through a wall. Let me see what time the Sargon show is. Sargon. 2 p.m. Right? Tomorrow's Wednesday. Yeah. 2 p.m. Central Time. Tomorrow is the Sargon show. Perfect. So let's do the fucking hell. Super chats. And then let's wrap up the show. Okay. Load. Oh my God. I hate everything. No, I don't want to do that. No, God damn it. All right. Thick Arab accent says, beware of good logic. They greet you with shalom, but their smile conveys of death. Crusader Saracen says, is it possible that instead of full split, that will never be peaceful, we go back to a pre-Civil War, full state sovereignty federalist system? That would seem workable. I wish we would. Let the states actually be self-determinative of their own laws. Thick Arab accent says, these Minnesota YouTube lawyers that the Satan tries to make beautiful, Allah marks them with that nose. Where Tiger Ray says, what do you think of the lawyer shaming the media is engaging in with the Gabby Petito case? I haven't been following the lawyer shaming aspect of that. But are they shaming the Brian Laundrie's family's lawyer? I mean, Laundrie's family attorney, I mean, he played it right. I don't know. Bad Dragonite says, hey, Nick, since you kept saying you like Symphony of the Night on Switch, I'd suggest the new Castlevania Advanced Collection on Switch, like $20. 3 of the games were made after Symphony and were meant to be like it. The 4th is Dracula X. Maybe I'll check it out. Mandy Carvizia says, glad you feel well. I almost cried for you, Nick. Oh, don't cry for me. I'm alive. Mario Carter 13 says, my nose will go on and on. Eldon Bainley says, hope you're doing better, Nick. Hashtag never vax facts. Malik Foxon says, on the plus side, you're better protected. Xenobit says, changed my profile pic. Now you have to see it too. Look, you are awful for that. It's that fucking guy Playboy bunny garbage. Blaine 20 says, my coworker Kevin, age 65, passed away alone in his apartment Sunday. Please pass along a prayer request for his family and friends. Will do. Will do, buddy. Malik Foxon says, I had no doctor because I just moved to Texas when I caught it. Doctors didn't want me coming in their office, so I was basically SOL, quarantined myself with some ibuprofen and 24-hour cough meds and an inhaler. Yeah. Yeah, that's basically it. Stephen Cooper says, get wrecked, scrub. Digitalis says, my condolences on your lung pow sicken. May you recover quickly from your near-death experience. Please accept this super chat to buy horse paste. Stephen Mulroney says, go make the ER look busy. Mario Carter 13 says, Nick consulting with the most trusted Dr. Pepper. Rick Nikita says, stop coughing. I can't. Eldon Bainling says, monoclonal antibodies don't help with your haircut. No, but they would help with yours. The gray one says, evening, Nick. It has been a hot minute since I super chatted last. Hit a financial snag, so been really stingy. Here's to your speedy recovery, my man. Hey, thank you. Thank you. Always take care of you before you donate anything to me. Eddie says, buy an oximeter and monitor your oxygen levels. I had it. An oximeter enabled me to get pneumonia help early. Serious Joker says, you are trying to make the congressman productive. Yes. Ben Frail says, Doc, your shit's fucked up and you talk like a flag. And what's in it? Well, like you talk like a fag and your shit's all retarded. Joel Reese says, was your doctor German? Named Dr. Bassoon? No. I like my doctor, but they're just not really helpful right now. Seagull Loather says, eating dung, not self-harm because Twitter is Pajit run. Smiley says, feel you, man. You're lucky it was temporary. I was permanently banned for saying murder was bad. You can't win in that place. Oh, yeah, I know. It's so stupid. It's so stupid. Jackson Kai says, can't get treatment because you are too healthy. Can't make an appointment because you're sick, yet they are extremely concerned about bleach. Wick Dipper says, if my doctor did that to me, I would make an appointment to tell him to his face that he's lost my business and that of anyone else I could convince. Two Hands says, emergency immune plus mix with tonic water and NAC. I couldn't get any NAC. They didn't have any at the store. I'm going to see if a different store has some. Rick Nikita says, stop coughing. Mario Carter 13 says, who'd win one weeb versus the entire military battalion? One weeb. Angron, the Red Angel. Welcome to Paralegal Status. Thank you for joining. Abubba22 says, Nick, those Spec Op guys played Metal Gear. They know not to mess with cyborg ninjas. True. Your mental illness says, new movie series, Chicano Ninja. Saint Sinner PA says, it's okay. He had me on his show. Thanks, Joe. Yeah, that's good. He had a couple people on today, which is good. David says, do you have anything on the Convention of States? It's our way of taking back control. Need some real genuine thoughts on it. I'll maybe put together a video about a Convention of States. Glenn Beck was talking about it like years and years ago. But it would give us back some control and it would cut the legislature out of it. Wick Dipper says, looking good, Nick. Keep up the good work. Maybe don't eat for another week or two. Thank you. Eldon Bainling says, Nick, check out Squid Game. Amazing show. I watched the first 4 episodes. Enjoying it so far. Shane G. Are you in that, Eldon Bainling? No, wait, that guy was a Packy. That's right. That's not you. Shane G says, the important thing to remember is 160th SOAR are just pilots and aircrew for Spec Ops troops. They probably didn't even have guns. Still disgraceful. True Lunchy. Oh shit, I'm sorry I missed this. Says, hey Nikki, can I shamelessly plug if I donate? Visit dpad.life for the internet's last based video game forum. Get well, Nikki. dpad.life is the internet's last based video game forum. Give it a check. Check it out. ASO says, so if Kiwi Farms is responsible for their users' posts, does that mean Zuckerturd and Jack Dorsey will be locked up forever? Or just no? No, just no. Just no. Craig Rode Jr. says, can you talk about the drone footage and how it was withheld in the Kiwi Farm in the Kiwi Farms case? You mean the Kyle Rittenhouse case? I haven't seen the drone footage yet. I don't know if it's been disclosed. But yeah, that came out at the last hearing that they had the surprise FBI drone footage. After a year, after over a year of time having elapsed, suddenly they got a gotcha drone footage that they have not that they had not shared yet. So that was nice. Bad Dragonite says, I wonder if the base Latino ninja is related to the base Catholic Latino who dual-wielded rosaries. What's their hero team name? Cray Slayer says, stop stressing out people. Nick's nose has a bigger chance of doing widespread damage than La Palma does. Andy Caravisia says, by the way, Nick, Arnold Schwarzenegger was painting and dipping his cigars in tequila, letting them dry and then smoking them. He says you can infuse cigars with any liquor and they burn better and taste better. You should try. Yeah, but I don't trust anything that commie says. R.W. Bimby says Kyle Judge has Warhammer 40K Space Marine shape. Isaac McAfee says, I propose a nickname for Kyle, the Garbage Man, for his keen ability to take out the trash. Jospy says, missed most of the Ralph streams aside from when it was breaking. Just want to say that guy is like the adult version of Eric Cartman. I wish Ralph all the best, and will now make fun of him literally forever. Habita Hubita says, the ironic fate of you not being fat enough, yes. I Hate Yankees says, on the topic of the country splitting up, Daniel Miller might make a good guess. He's the leader of an independence movement in Texas. Okay. Habita Hubita says, by the way, you are insanely skinnier. Said that your diet had to be made in China. In Trump voice. Sad. Joshua says, please make a full what if video on David's Convention of States subject that goes over how it could happen and what problems they would they face. Yeah, I think that would be a good video. I don't know how soon I'll be able to put it together, but that is a pretty good one. Uriah Wright says, this audio is so boomered, even Nick of all people is cringing at it. Organized Arizona Politics says, Jesus, thanks for the loss of hearing in my left ear. Driving Uber and I chucked my headphones across the car. Passenger was confused. Lol. Oh man, you should have that playing through your car stereo, ruining every Uber passenger's experience. El Ninja. No, why would you do this? El Ninja says, your Americanos spec up son patetizos, Requita. They've shamed sas familias. Them hombres better cuida su espladas when I escape. Fucking bastard. Ginger Ninja says, quoting the judge, Die Ghostfish says, I think the one distinction in cop versus non-cop use of force is the cop's duty to retreat is balanced by a duty to catch. Not relevant since Kyle ran. Kyle only has a duty to retreat in Wisconsin if he provoked the fight. If Kyle did not actually provoke the encounter, he has no duty to retreat. But again, it's not relevant because he did retreat anyway. So either way, Kyle should be fine on that front. But right now, it's kind of looking like he might catch that misdemeanor charge for the minor in possession. Ginger Ninja says a reasonable person would have shot all three of them just sooner. Kyle showed godlike restraint. I would have shot all three of them. I would have shot Rosenbaum way sooner. Way sooner. I would have shot him right in the dick. And then I would have Googled him while he was sitting there whining on the ground. And I would have found out that he was a pedo, and I would have shot him in the dick twice more. And then I would have shot him in his mouth. And then I would have shot him again. And then I would have lit him on fire. Jackson Kai says, ambient gunfire is just common sense. What a fantastic way to show they fail both as leaders and law enforcement. Yeah. Yeah, that's. Well, there's just ambient gunfire. Oh, okay. That's fine. Ava M says, rackets, bruh. You know there's no best COVID life. Drunk in solidarity, bro. I live my COVID life spooning in bed with Babylon 5 reruns. Yeah, it's a lot of time spent in bed. Lots of time. Ginger Ninja says, Dr. Black puts his pronouns he, him in his Zoom title here in a bit. Tet says, is use of force expert just a PC term for Jedi Master? Get better, COVID sucks. Yogurt and soup help, though. Yeah, I'm really hungry right now. William Barnes says, calling pedophiles and Antifa rioters people is perjury. Habita Hubita says, not gunt cat, gunt you. Where the fuck did that go? Let's see. Kinda X122 says, if the defense doesn't smash this claim by the prosecution, I'm going to scream. Sarn Zero says, do me a favor and call him Sargoy of Kakad. Oh, no. That's rude. Jackson Kai says, hope you and Lady Raggets feel better soon. Get some sleep. Looking forward to Sargon. Intimidator 0108 says, hey, Nick, hope you're feeling better. Not sure if you heard, but after the Xfinity race on Saturday at Talladega Superspeedway, during the interview with the winner, the crowd was chanting, fuck Joe Biden. I did. I've seen that in a lot of places. But they're actually saying, let's go, Brandon. R.W. Bimby says, COOF, don't eat oats or apples. That's horse food. True. Wick Dipper says, it's so cute that you expect any other reaction from a bunch of Air Force Zoomies. JD Freeze says, I ordered knack from Life Extension. Stores are out. Nice to Lizard says, get some shark fin soup to cure your Chinese AIDS. And Mandy says, hungry. What can I bake for you, Nick? Nothing. I'm going to go make some rice, I think. Rice, and I'm going to dump chicken broth in it. Because chicken broth with rice is delicious. Goes down easy. And it's a nice way to eat. And then finally, Phil a booty. Wait, no, shit. Bad Dragonite says, also maybe just me, but Castlevania would be a cool Halloween time game for Twitch. Phil a booty says, Nick, in an Australian high court in New South Wales, they put forth a study that found that the Fauci ouchie makes the Delta more transmissible. I'll clip it out and find the paper and get it to you ASAP. Well, there you go. Very, very interesting what the Australian courts are finding out. And then Mandy Carvicia says, let's go, Brandon is banned on Twitter now. Oh. All right. All right, guys. That's what we got. Thank you for hanging out with me tonight. We'll see you tomorrow for Sargon. And then assuming tomorrow is a day like today, should be able to do the Sargon show and then another show at night. And we will resume the Kyle Rittenhouse hearing. I plan on covering every minute of the Kyle Rittenhouse trial that is publicly available for coverage. And that, this hearing is part of that. So we'll see how it goes. I will not be on Twitch tonight. I do need to get some rest. So sorry for that. Hopefully I'll be back on Twitch very soon. We got to watch Ong Bak and we've got to watch the Die Hards, and we got to watch all sorts of good shit. So, yeah, we'll catch you guys soon. Hope you have a good night. Until tomorrow. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now.